Welcome to our deep dive. Today, I want you to imagine you are ordered by a high court judge to pay massive monthly child support for children who are not biologically yours.
Right, and whom you never legally adopted.
Exactly. Now, imagine receiving that order, contacting your legal counsel to urgently appeal what you view as a catastrophic financial error, only to be told that you are legally barred from appealing the decision.
Yes.
The doors to the higher courts are completely locked. Welcome to the ruthless, high-stakes reality of South African family law.
It really is a reality that often shocks individuals when they first encounter it. You know, the traditional perception of the legal system involves this methodical search for absolute truth.
Sure.
Where every error can be escalated and corrected by a higher authority. But matrimonial disputes, they operate under entirely different, highly pressurized conditions.
They really do. And today, our deep dive focuses on a legal case study authored by Cape Town divorce attorney Nick Elliott. It's titled, Rule 43 is Not Open to Appeal.
A very fitting title.
Indeed. Our mission is to guide you through the strict procedural boundaries of interim maintenance in South Africa. We will examine exactly why appellate courts refuse to entertain appeals on these provisional orders.
Even when the financial stakes threaten a person's immediate livelihood.
Right. And the foundation of our analysis is a specific Supreme Court of Appeal case. B.E. versus N.T. and Others, citation 2026, ZASCA 25. Okay, let's unpack this.
We should start with the facts.
Yes. We need to look closely at the specific familial conflict that triggered this massive legal battle because it represents a scenario becoming increasingly common in modern society.
It is. The foundation of the B.E. versus N.T. matter rests on a blended family dynamic.
Yeah.
So we are looking at a situation where a husband and wife lived together, and the husband shared the home with his wife's 2 children from a previous relationship.
Right.
The critical fact here is that they function socially and practically as a single family unit.
Okay, that makes sense.
However, the husband never undertook the formal statutory process of adopting those 2 children.
Wow, okay. That creates a profound legal vulnerability the moment the relationship deteriorates. I mean, they functioned as a family behind closed doors, but they lacked the legal architecture of adoption.
Precisely. And when the couple inevitably separated, the wife approached the High Court for immediate relief.
Utilizing Rule 43?
Yes, she utilized Rule 43 of the Uniform Rules of Court.
And for anyone unfamiliar, Rule 43 is a legal mechanism designed to provide temporary financial support, custody arrangements, and contributions to legal costs while a divorce action is actively pending.
Yes, and the mechanics of a Rule 43 application are what make it so contentious. I mean, these are not full trials.
Right, there is no witness box.
Exactly. A judge makes a determination based largely on sworn affidavits. So in this case, the wife would have submitted documents demonstrating that the husband had assumed a parental role.
So things like bank statements.
Yes, bank statements showing he paid for their school fees, evidence that they were on his medical aid, or proof that he covered the primary household expenses.
Okay, and based on this documentary evidence, the High Court recognized his assumed parental role and ordered him to pay substantial interim maintenance for those stepchildren.
They did, and it did not stop at child maintenance.
Oh, really?
No, the court also ordered him to make heavy contributions toward the rental expenses of the wife's household and to pay a significant lump sum toward her legal costs.
Wow, so she could fund the upcoming divorce litigation against him.
Exactly. The financial burden placed on him overnight was staggering.
Naturally, the husband launched an aggressive legal countermeasure. He sought to appeal the High Court's order.
He did, and his argument was not merely that the amount was too high. He attacked the legal principle itself.
Right.
He contended that the High Court was inventing a novel and entirely incorrect development of the common law. You see, South African common law does not traditionally impose a reciprocal duty of support on a step-parent merely because they live together.
Yes, he argued that the court was creating a financial obligation out of thin air. Well, it sounds like the High Court applied a financial tourniquet at the scene of a severe accident. I mean, a Rule 43 order is meant to stop the bleeding, to ensure the children have food and a roof over their heads until the patient can reach the hospital.
Which in this scenario is the final divorce trial.
Right. But if the husband never legally adopted those children, isn't he entirely justified in arguing that this financial tourniquet has been forcibly applied to the wrong patient?
It is a very compelling argument.
Because by ordering him to pay for children he has no statutory duty to support, the court is inflicting a severe financial penalty on an innocent bystander. He argued this burden was final in effect, and therefore he demanded the right to appeal this erroneous tourniquet to a higher court.
Well, you say it was applied to the wrong patient, but look at this from the High Court's perspective.
Well,
For years, this man willingly acted as their provider.
sure.
If the court pauses the entire process to debate the exact statutory biology and common law jurisprudence at the roadside, well, the patient bleeds out. The children get evicted next week. The court prioritizes keeping a roof over their heads based on the established status quo of the household.
But surely the Supreme Court of Appeal, the second highest court in the country, would have to step in if a lower court completely misapplied the common law.
You would think so.
Because if the foundation of the order is legally flawed, the appellate courts exist to correct that flaw.
What's fascinating here is that the Supreme Court of Appeal completely bypassed the substantive argument.
They did.
Yes, they did not adjudicate whether the High Court was right or wrong to impose a duty of support on a step-parent.
Wait, so they didn't even debate the common law?
Not at all. Instead, they struck the appeal from the roll entirely. They refused to hear the matter.
They hit an absolute brick wall. The highest appellate court simply closed the door on his argument, regardless of its potential merit.
Exactly. And they relied on a very specific, uncompromising piece of legislation. It's Section 16, subsection 3 of the Superior Courts Act. This statute explicitly and unambiguously bars appellate courts from reviewing or hearing appeals on interim maintenance orders. The wording leaves zero room for judicial discretion.
So it does not matter if the lower court made a glaring mathematical error or if they misread the common law. The prohibition on appealing a Rule 43 order is absolute.
Absolutely.
So what does this all mean? Why would the legislature intentionally create a system where a potentially erroneous, highly expensive court order cannot be challenged?
It is a difficult concept to grasp.
Because the fundamental premise of a justice system is supposed to be the correction of injustice. How does this strict statutory bar actually benefit you, the citizen navigating the courts?
It comes down to a brutal but necessary calculation regarding the weaponization of the legal system. Section 16, subsection 3 is designed specifically to shield economically weaker spouses.
Ah, I see.
Because divorce litigation is defined by massive emotional volatility and almost always a significant disparity in wealth. If interim orders under Rule 43 were subject to the standard appeals process, well, a wealthy spouse would use the appellate courts not to seek justice, but to wage a war of attrition.
Right. They would use their superior financial resources to essentially starve out the opposing party. If an order is made against a wealthy husband to pay maintenance and legal costs, he could simply file a notice of appeal.
Yes, and that action alone traditionally suspends the operation of the order.
Wow, so the money just stops flowing immediately.
Exactly. That is the exact nightmare scenario the legislature is preventing. Consider the timeline. An appeal to a full bench of the High Court, and then potentially a subsequent petition to the Supreme Court of Appeal, can take anywhere from 2 to 4 years to finalize.
Right.
So if the interim maintenance is suspended for 3 years pending an appeal, the economically weaker spouse and the children are left destitute.
Yeah, they cannot buy groceries. They cannot pay school fees.
And crucially, they cannot afford to hire lawyers to fight the actual divorce trial. The wealthy spouse wins by default, because the weaker spouse is forced to capitulate just to survive.
So the law is essentially making a philosophical choice. It is willing to tolerate an incorrect financial penalty being imposed on one party in the short term to prevent the absolute financial ruin of the vulnerable party in the long term.
Precisely. The system prioritizes immediate survival over immediate legal perfection. And if we connect this to the bigger picture, allowing appeals on provisional orders would also completely paralyze the national justice system.
Right, the backlog would be insane.
The appellate courts would be perpetually clogged with tens of thousands of interim matrimonial disputes. Judges at the Supreme Court of Appeal level are meant to be determining complex constitutional matters and final commercial judgments.
Not deciding whether a husband should pay 10,000 Rand or 15,000 Rand a month in temporary rent.
Exactly. The legislature determined that the immediate stabilization of families awaiting a divorce decree vastly outweighs the potential financial prejudice a wealthier spouse might suffer temporarily.
That clarifies the legislative intent beautifully. It is really about preventing the legal process from becoming an instrument of abuse. However, this creates a deeply frustrating procedural dilemma for you, the listener, to consider.
It certainly does.
Because if you find yourself in the position of the husband in this case, ordered to pay severe financial penalties that you believe are fundamentally contrary to the law, what is your actual recourse?
It feels very limiting.
If you cannot go up to a higher court to appeal, are you simply trapped paying this money until the final divorce is finalized years later?
You are not entirely trapped, but your options are strictly channeled. The law recognizes that circumstances change, and interim orders can sometimes be profoundly unjust in their application. Therefore, it provides a specific safety valve. If a Rule 43 order needs to be challenged, the correct procedural recourse is not an appeal to a higher court, but rather a Rule 43 subsection 6 application.
A Rule 43 subsection 6 application. Let us break down the mechanics of that. How does it differ practically from the appeal he attempted at the Supreme Court of Appeal?
The distinction is jurisdictional and factual. An appeal asks a higher court to declare that the lower court made an error based on the exact evidence presented on that specific day.
Right.
A Rule 43, subsection 6 application requires you to go back to the exact same court, the high court, and ask a judge to reconsider the order based on a material change in circumstances.
Ah, I see. So it is a request for a variation of the existing order, not an appellate review of the initial legal reasoning.
Exactly.
So you cannot go up the ladder, you must go back to the source.
Yeah.
But what constitutes a material change in circumstances? If the husband's argument is simply the judge got the common law wrong, that doesn't sound like a change in his circumstances. That sounds like he's just unhappy with the result.
Which is exactly why a Rule 43 subsection 6 application is difficult to win if you are merely trying to relitigate the same facts. A material change means something in the real world has actually shifted.
Like what, for instance?
Well, perhaps the husband lost his employment and can no longer afford the exorbitant amount. Or perhaps the wife secured a highly lucrative job and no longer requires the same level of support.
Okay.
Or perhaps one of the children moved out of the home. You must prove to the high court that the financial reality on the ground has fundamentally altered since the original order was granted.
This highlights a vital distinction for you to grasp when analyzing South African family law. There is a massive, impenetrable wall between interim relief and final relief.
Very much so.
Because interim Rule 43 orders are purely provisional. They are blunt instruments. As we discussed, they are decided swiftly in a motion court, frequently relying entirely on a strict page limit of sworn statements.
Yes. There is no oral testimony. There is no cross-examination of witnesses to test the truthfulness of those statements.
Right.
Because of that inherent limitation, they are not designed to be legally perfect. They are designed to be fast. And because of their provisional nature, they do not bind the trial court in any way whatsoever.
Oh, really?
No. When the matter finally proceeds to a full contested divorce trial, the trial judge starts with a blank slate.
Okay.
At that final stage, the court will hear days or even weeks of oral evidence. They will subpoena complex financial records, cross-examine both spouses, and thoroughly analyze the competing legal arguments.
So the trial judge retains complete freedom to alter the maintenance decisions entirely.
Completely independent of whatever the Rule 43 judge ordered 2 years prior.
Here's where it gets really interesting. Because Rule 43 proceedings are designed to be swift, factory-line justice out of necessity, they are fundamentally not the appropriate venue for developing or redefining the common law of the country.
That is the core jurisprudential lesson of the B.E. versus N.T. case. Developing the common law is one of the most serious undertakings a judiciary can engage in. To determine whether South African law should permanently evolve to impose a strict reciprocal duty of support on stepparents who have not legally adopted their stepchildren well, a court needs a comprehensive evidentiary crucible.
Definitely.
It must examine public policy, the constitutional rights of the child, the psychological bonds formed during the marriage, and the long-term societal implications of such a ruling.
You simply cannot adjudicate a novel legal duty of that magnitude based on 50 pages of conflicting affidavits in a rushed 45-minute interim hearing. I mean, a hearing that was only scheduled to ensure the electricity doesn't get cut off before the trial begins.
You really cannot. Novel legal questions regarding the obligations of blended families or any significant evolution of matrimonial law must be explored in the rigorous environment of a trial court.
Yes.
By striking this matter from the roll, the Supreme Court of Appeal sent a definitive, unambiguous message to all legal practitioners in South Africa.
Which is,
Do not attempt to litigate complex, novel common law developments through piecemeal interim applications. You must endure the interim phase and wait for the trial.
This analysis provides a stark but necessary look into how the justice system triages human conflict. The Supreme Court of Appeal emphatically reinforced the strict jurisdictional limits placed on interim maintenance.
Yes, the statutory bar under Section 16, subsection 3 is an absolute brick wall.
Rule 43 is designed to be a temporary, modifiable measure for survival. It is not a final judgment, and therefore it is resolutely closed to appellate review.
The architecture of this system serves a vital dual purpose. First, it aggressively protects economically vulnerable parties from being subjected to a war of financial attrition through the higher courts.
Right.
Second, it protects the integrity of the law itself. It preserves the trial court's essential role as the ultimate arbiter of complex legal duties,
Ensuring that any new developments in the common law are decided upon a fully tested, rigorously cross-examined evidentiary record. It is a framework that attempts to balance the urgent, often desperate need for practical fairness with the necessity of rigorous legal procedure.
Yes, it favors survival today over truth tomorrow.
Exactly. However, this strict separation between interemergency and final legal truth leaves us with a highly complex, almost paradoxical scenario to consider as we wrap up.
It certainly does.
We have established that a trial court retains complete freedom to alter decisions at the final divorce stage, evaluating the law and the evidence with absolute comprehensive authority. We want to leave you with a final provocative thought regarding the brutal mechanics of this system. Consider the money that changes hands during this waiting period.
Right, those interim payments.
Yes. If a trial court has the ultimate authority to redefine the case, what happens to the hundreds of thousands of rand already paid out under a heavily contested interim order if the final trial ultimately decides that the husband was right all along? What if the trial judge rules that there was, in fact, never any common law duty to support those unadopted stepchildren in the first place?
The money's already been spent.
Exactly. It's been spent on rent, groceries, and legal fees. How does the law unwind a financial tourniquet that was applied and tightened every month for years to the entirely wrong patient?
That is a profound question.
It really is. Thank you for joining us for this deep dive into the procedural boundaries of South African family law.